Hello and welcome to all of you to this webinar organized by Kashmir Institute of International Relations and World Muslim Congress on the sidelines of the 46th session of Human Rights Council. As you know, the title of today's webinar is Abusive Legislations to Suppress the Political Demands of People of Jammu and Kashmir. As you all know, that the people of Jammu and Kashmir have been struggling for their rights celebration over the last 73 decades. The UN recognized dispute, and India and Pakistan agreed to implement the UN resolutions on Kashmir, but thereafter, the denial on the side of India has resulted in the regime of human rights violations. In occupied Kashmir, India introduced a series of laws in 90s onwards to suppress the people's struggle, like Armed Force Special Power Act, Public Safety Act, National Security Act, TADA, etc. So many laws, which were in a way abusive laws and in contravention to the international human rights standards. And after 5th of August, what we saw, India dismembered the state and then introduced a new set of laws, new legislations like Reorganization of Jammu and Kashmir Act, and then Domicile Act, Land Reformers Act, new education policy, new media policy, and extra, many legislations. These all legislations were aimed at to suppress the people's struggle for self-determination and to change the demography of the state and defeat the concept of self-determination in occupied Jammu and Kashmir. To discuss this, we have a very learned panel today. I have with me Jatinder Singh Gariwal. He is a Canadian lawyer who has obtained his Juris Doctorate from Auguste Hall Law School. He has worked in human rights for the last 10 years. He previously worked in the Office of the High Commissioner, Human Rights Law and Staff Officer, High Commission, Rule of Law. Welcome to this webinar, Mr. Jatinder Singh Gariwal. I have with me Ambassador Dr. Hisham Bosad. He is the Ambassador at Large of the International Human Rights Commission. He is Special Representative and Envoy to IIOJK and IPSP, that's International Parliament for Safety and Peace to the Middle East. Welcome, Ambassador, to this webinar. I have with me Ms. Rihana Ali. Rihana Ali is a well-known activist of Kashmir. She's the Secretary General of Tehreek Kashmir, UK, and she hosts a show Live with Rihana. She is a lecturer and writes on different issues, including that of Kashmir. I have with me Barrister Nida Salam, and human rights activist from Kashmir. Nida is a frequent writer on various issues, especially on the human rights in different newspapers in Pakistan and abroad. Welcome, Nida. She's a practicing lawyer at the High Court of Islamabad. Nida, welcome to the show. I have with me Dr. Syed Vikas Ali Kansar. He's head of Department NAMAL at National University of Modern Language, head of Department of Public Governance. Dr. Vikas Ali is a budding scholar from Azad Jammu and Kashmir. He has written on the different issues of youth in Azad Kashmir and youth empowerment in the both sides of Kashmir, and has been working with the youth from both sides of the line of control to in search of peace and for their better future. Dr. Vikas, thank you for joining us. Finally, we have with us Advocate Parvez Ahmed Shah. Parvez Ahmed Shah is a lawyer from Indian occupied Kashmir. He is currently the Secretary General of All Parties Hurriyat Conference, the group which is advocating the political rights of people of Jammu and Kashmir. He represents All Parties Hurriyat Conference in Islamabad. Advocate Parvez Shah, welcome to the show. First of all, to begin with, I will like to request Jai Singh Gariwal for his remarks.
Thank you, everyone, for inviting me to this panel. Again, I apologize if anybody hears dogs barking or children. I am at home, and you may hear such noises. My area of expertise is the Punjab region. I work with an organization called Sikhs for Justice, and we are advocating for a peaceful referendum to resolve the Punjab question, similar to what Kashmir is asking for, and which was mandated to Kashmir by the United Nations. My topic of discussion will be the weaponization of language and how Indians have effectively disenfranchised legitimate demands for people's right to self-determination in mainstream media and in the Western world as a whole. So looking back, we want to look at the first event. Unlike Kashmir, the Punjabi Sikhs decided to stay with India when India was created. However, similar to the warning that Jinnah had given the Punjabi peoples, we quickly learned that India was not a free place for us. We began to see systematic discrimination. To date, the Indian Constitution does not recognize Sikhism as a religion. Nevertheless, the Sikhs engaged in civil disobedient acts in an attempt to regain their independence. In 1970, the Sikhs put forward what was called the Anandpur Sahib Resolution, which was a political solution to the issues they were having. This was the first time that the Indians actually weaponized language because they portrayed it as a secessionist document. This had the effect of creating divisions, and which ultimately led to the 1984 Sikh genocide. Now, the word genocide is a very political issue, and the definition itself is very clear. When you target a community based on their ethnic, national, racial characteristics or religious characteristics, that would be defined as a genocide if you kill in complete or in part those people. So the Indians quickly turned that act of November into what they called anti-Sikh riots. So they portrayed it as a community divide, not a systematic campaign by the government to wipe out a people in 3 days. So that was the first act that we saw where the Indians delegitimized victims of their rights to grievance and to get justice. Moving forward, the demand for Khalistan, the independence of Punjab from India, is a legitimate demand, which is enshrined in the United Nations charters and which is recognized as a right of peoples, not of states. So the Sikh peoples attempted to exercise that right, and that became terrorism. So today, moving forward, because it's a long history, moving forward to the year 2020 or 2021 now, the Sikh people have decided to resolve this issue through a democratic method, which is a referendum. We've asked the Indians to allow a referendum in Punjab to resolve this question. If they are confident in their governance of Punjab, the answer would be, yes, we wish to stay within India. If it's not the case, the people should be allowed to exercise their rights. The Indians refused to hold a referendum, so we said we would hold an unofficial referendum. An unofficial referendum is non-binding on anybody, and some may say this is an exercise and that's going to go nowhere. However, the Indians have now labeled that act as a terrorist act. Sikhs for Justice as an organization is not recognized in Punjab or in India. We are not registered anywhere in India at all, but we are registered in Canada, in America, and in England. The Indians have now labeled Sikhs for Justice a terrorist organization for their demand for a referendum. Our, different members, there's one by the name of Mr. Gurpatwan Singh Pannu. He is also a lawyer from New York. He is now labeled an individual terrorist. Other members have also been labeled terrorists. So the whole point of this discussion is that the Indians are today using language, using international labels, which have serious weight and serious repercussions on peoples, to delegitimize legitimate demands. So for example, so many of you may be aware of the farmer demonstrations that are happening in India, predominantly run by Punjabi Sikhs. Again, that is another act of anti-national activity. Well, the question becomes, who defines what is national? And if you are anti-national, what is the ramifications of that, right? And that is where we stand in India today. India is great at weaponizing language. They use these terms to disenfranchise people, the people of Kashmir as well. People of Kashmir have a legitimate demand. It was recognized by the international community. Why is it terrorism? Why is it defined as an act of terrorism? Punjab was divided into 3 areas, which the Sikh people contested. It should not have been divided the way it was. Today, Kashmir is being divided. So the same mechanisms that are used in Punjab seem to be replicated in Kashmir. Punjab is flooded with drugs and alcoholism. That will be the same future for Kashmir. They will make sure that they destabilize and they have a flood of Indians come into the region of Kashmir. So they then change the demographics, as been pointed out. So how do we address this? And that's something, the Kashmiri people and the Punjabi people can work closely on. We have a shared history. We've worked together in the past, and we should continue to strengthen our demands that, look, we aren't separatist movements. We are talking about the dissolution of India. India as a nation state, as the way it stands now, does not represent its people. South India wishes to be independent. East India wishes to be independent. North India wishes to be independent. And for all we know, there may be other regions. So we need to work together as best we can and not allow India to weaponize this language. So just a caveat to this, Sikhs for Justice donated $10,000 to the Human Rights Council, the United Nations Human Rights Councils. Well, India labels us as terrorists. So they asked the United Nations to, give back that money. And the United Nations responded back saying, no, we will not give back that money. We will not accept money from organizations we deem as terrorists, not arbitrary designations by India. Now India is furious. Now you see how they attempt to curtail dialogue at the United Nations with Sikhs for Justice and the United Nations. So these are the attempts that the Indians are making against us. They have changed laws. They said individuals can be now labeled terrorists, and now they've implemented it on our organization and individuals within our organization. And today we need to work together and stand together and make sure the world knows demanding self-determination is not a crime. It is a right enshrined in international law. Thank you.
Thank you, Jay Singh. You rightly pointed out India has weaponized the language. But we can also see that when India comes to the international criticism from international human rights organizations like Amnesty International, Human Rights Watch, or likewise the other organizations around the globe, or the Office of the High Commissioner itself, or the human rights procedures, what Indian delegates have to say, or for that matter, what Indian Foreign Minister yesterday said, that we do not need any certificates from the self-styled custodians of human rights. They call all those human rights organizations and even the Office of the High Commissioner as self-styled custodians of the human rights. And then on the other hand, what they do, they take the different envoys and delegations to Kashmir to show them, to showcase the normalcy in Kashmir and get certificates from them that India is a democracy and everything is normal in Kashmir. That is the dichotomy of the Indian system which we are facing. And you rightly pointed out, we need to work together to expose the Indians. Like you pointed out, that India is flooded with drugs and alcohol, and the same is happening right now in Kashmir. And we have seen a video going viral, someone from the men from Uttar Pradesh, the guys who were brought over there, they were drinking alcohol in an open space and then asking that now the whole Kashmir is free for them. And they have flooded already Kashmir with Indians who are nearly 900,000 Indian troops and other paramilitary forces there. And till date, they have issued 3,300,000, more than that, domiciles to the Indians. And thereby they are going to change demographics. It's all because of these abusive laws which we are discussing. I will now straight away go to Syed Vikas Ali Kausar, Dr. Syed Vikas Ali Kausar, to have your perspective of the situation. Dr. Savi, on the floor.
Thank you very much, Altaf Sanwani, for having me, inviting me to this very important webinar regarding how the tweaking and tampering with the laws actually is intended to political suppression of the people of occupied Jammu and Kashmir. Not only post 5th of August 2019, but if we see that once the government of the Mehbooba Mufti was toppled and then there was a governor rule, we see the intent of the government, current Indian government, towards disempowerment of the people of Jammu and Kashmir from the actions and acts of the governor's rule. If you see from even June 18 to December alone, there have been major tweaking and have been a lot of uh, uh, action that have been taken. Like if you see the PSA, there was a change made through governor rule insertions that uh, the people who were charged and who were cased under this PSA, initially it was that they have to be confined, they have to be put in the jails within the territory of state of Jammu and Kashmir. But with that change, you see that they can be sent to any of the jails outside the Jammu and Kashmir. So making it very clear that the way they were trying to trample the second, there was an incident of a rape, a very sad incident in Kathua, a rape case. You have seen that there have been a land act, there have been some tweaking with that land act before even 5th of August 2019, where there was a group of the lawyer who were defending actually of the person who was involved in that. There was a group called Ikjut Jammu. So they were asking to not only make a substantial change in the land rights, so that this majoritarian rule, or maybe the majority of Kashmiri region, can be controlled and minimized. And then also about the Human Rights Commission, if you see in the occupied state, when we see that there have been another change until December, I guess 2018, when there was a new insertion made that they were denied to hear or entertain a case a case of a year ago. So there was a time limit put on that. So the idea is that this was in, of course, a part of a larger plan. And then comes the post the 5th of August 2019. If we see particularly the land, Kashmiri rural community has been quite self-sufficient, and their resistance particularly has been because of their self-sufficiency, and that has been a core to their sustenance. So the idea was of a larger plan was to not only counter this resistance through political means, but also economically trample the community and the constituency of the people, so that one way the other way they have been kneeled down and see in Kashmir. Basically four major laws historically, if we see that were there for the land preservation. That included Alienation of Land Act 1938, yes, and then there was a big landed state Abolition Act of 1950, and then there was a Land Grant Act of 1960 and Aggregating Law Reforms of 1976. Historically, we see that the division of the land, particularly during the Sheikh Abdullah's rule, was one of the very cherished thing at that time, because the land was divided among the community, so that it also empowered those people, landless people, particularly are the marginalized communities. And with that, if you see, first two, 1938 and 1950, was totally abolished, and rest of in the two of 1960s and 76, the clause of the permanent resident particularly was abolished. So that has not only just disrupted the rural economy, but also opened a sort of a floodgate for industrialist and commercial activities within Kashmir without their consent, particularly, that we need to see. Also, there have been the Act of Jammu Kashmir Development Act of 1970. I mean, for everything to bring under the name of development zones, they have changed that existing laws and put it, under the central law, so that no more local consent. Since the assembly is not there, but so these procedural changes are made so that no permission or anything could be acquired from the people simultaneously, local people particularly. And also the 1990 law of land acquisition, where that was also trampled, that no land allotted or leased out for residential purpose for people, those who are not permanent residents. They were also, that was also targeted. And then if you see under the strategic areas, there is a new introduction of creation of enclaves for the forces, and that have been exempted from the Local Development Act. Likewise, you had the low costing housing societies that are meant for Kashmiri people, but now open for the citizens across of Indian citizens, particularly across the country. The idea is, even there was a change in the real estate laws and other agriculture land as well. There was a particular department, a revenue board, another bureaucratic organization under a bureaucracy was created. Just the entire idea is that the reforms carried on in 1967 or other laws, just to make sure that the consent, the overall authority of the people has not only been eroded, but it severely curtailed, and all these things were put under the central law. The idea is, if their idea was to mainstream Kashmir, if their idea was to bring the development in Kashmir, I guess Kashmir is far from development. Kashmir is far from normalcy. It further alienated state. It further alienated people, and there is no semblance of peace. There is no initiation or a hint of any political process in Kashmir, particularly. And that is, I mean, this also brings into one question that if there was all to mainstream and put the Kashmiris into so-called mainstream, why still there is the draconian laws like Public Safety Act and other stringent measures, particularly specifically dedicated or directed towards Kashmiris? So it all talks about the intent and the will of the government that is over there. And lastly, I would like to say that, of course, this was part of a broader agenda of the BJP government, not only to disempower Kashmiris, but to curtail their political and social movement that is largely indigenous, and the right to self-determination is the fundamental right enshrined in the UN Charter. Neither Kashmir came back to the normalcy, neither it economically got empowered. Now the only thing left with them is the language, particularly, which is a tool of resistance for Kashmiris particularly, and it's a centuries old. So now there is a continued and systematic effort is not to disempower them from their language, but also new education policy. If they say that there could be the multiple mother languages, ideally there is no difference to it, but the problem is the intent matter, particularly the intent of the government is to further divide the Kashmiri society and communities particularly. So just to conclude this, Kashmiri's resistance have been, of course, very much central to their right to self-determination from the beginning, and that right that has been given to them by the United Nations and in multiple resolutions. So their resistance, particularly, no matter it's on economic or political and other front, will continue. The only thing that we need to see is that Kashmiris have been laying sacrifices, but overall the state apparatus of Indian government, the way it reacted and resisted against the Kashmiris, this is totally unlawful and illegal. And right to their land, right to existence is the fundamental right. And that is the question for the entire world community, to see that Kashmiris have all right to live peacefully with their fundamental political rights. I thank you, Mr. Wani.
Thank you, Dr. Sayyid Vikas Ali, for your contribution. You rightly pointed out the intent of the government of India is to disempower the Kashmiris and to impinge upon their right to self-determination. And one of the acts which they recently introduced was the merger of civil services cadre with that of the services cadre of Arunachal Pradesh, Goa, and Mizoram. And we have seen that since this act was introduced, this merger was done, we have seen that now the 70% of the bureaucrats are from the mainland India, and only 33% are from Kashmir, and this marginalization goes on and on. To bring a gender balance, and I will now go straight away to the UK to Ms. Rihanna Ali for her deliberations. Ms. Rihanna, you have the floor.
Assalamu alaikum and good afternoon. Assalamu alaikum and good afternoon, as I'm based at UK. First of all, I would like to thank KIIR and WMC team to give me opportunity to be a part of this great conference and to meet honorable speakers of this panel. In regards to the topic today, I would like to start with a few simple words to make it easy for some viewers to understand the situation of Kashmir and the relationship Kashmir has with Pakistan and India. Just a few words to go forward. Also, I would like to clear the confusion of the difference between an occupier and an administrator before I start talking about the laws. We see India keep accusing Pakistan by comparing and making it sound worse than India when the situation is opposite. As the world knows, and can't be misguided, especially after the EU disinformation lab report. My colleagues, since the Kashmir dispute took place in 1947, Pakistan has always had an MP, in the administrative Kashmir called Azad Kashmir. But India, in the opportunity available, appointed a CM as a never accepted Kashmir as a disputed area. Although it was India who approached United Nations, as it had feared that it may lose the whole Kashmir to Pakistan, as the Kashmiris stood by Pakistan per their standby agreement. India did not stop. India did not stop after that, and India for years has been denying the rights on both sides of the Kashmiris of the right of self-determination as a referendum by rejecting Pakistan on a number of occasions the opportunity to solve the ongoing issue between the two countries. Between the two countries, which has been going on from 7 decades. After 5th August 2019, India did a forced marriage with Kashmir. In simple words, although it claims to be very liberal and it says that India is the 5th democracy in the world. But when Pakistan is having a love marriage, in simple words, with the wishes of the citizens of GB as they desire to be part of Pakistan since the 3rd of November 1947, there is a huge difference. With a love marriage, things can be sorted, but with an arranged marriage, things can never be sorted, and it cannot last for long. India has signed and India has signed a covenant with the United Nations that it will not violate human rights, but India is not obeying by it. I would like to talk about a few laws here, but first thing I would like to say that no law applies to Jammu and Kashmir, and the reason is that it's a disputed area. So we are, as Kashmiri, not obligated to follow any laws by India. The few laws I'm going to be talking today are going to be PSA 1978 and DAA 1992, AFSAFA 1990, and AUPA 2002. I will start by the Disturbed Area Act 1992. In this law, local police are trained within 6 months to take over the authority from the army, so they can deal with the violation happen in the area. But after a long time of this law being in the area, in 1998 it lapsed, and the legal requirement was not met. And I would also like to go on the next level, which is going to, next law, which is going to be the Public Safety Act 1978. In the Public Safety Act, anybody can be detained and they can be put away in prison for 2 years. And before the 2 years end, it could be extended. This law comes in operation with Section 13.2, which is a misuse of power. Under this law, even children of 9 years old, please note, children of 9 years old have been detained, and any Kashmiri of any age can be detained, and Kashmiri leaders, as we know, have been detained under this law and been placed in India in different jails. This is a law which has touched upon of many lives of the Kashmiris. After 4 weeks, an advisory board decides that if they are going to be convicted or not convicted under this misuse of power. The next law I'm going to be touching upon is going to be the law called UAPA 2002. Individual can be arrested and property can be seized, even if promoting an activity. The definition of this law of a terrorist has been expanded to give police power to dismiss against the principle of innocent until proven guilty, which is a violation under the International Covenant on Civil and Political Rights, which recognizes the above which recognizes the above principle as a universal human right. It also violates the Indian Constitution as the right of equality under Article 14, the right of freedom under Article 19, and the right of live with dignity under Article 21 before a trial. So in this law, like there is no trial to actually start with. Like they can apply this law and then they can think about it if there will be a trial, but normally there's no trial. Most convicted by this law are minorities, journalists, or human rights activists. I would like to continue by saying you can get convicted under this law for advocating unlawful activity. Under Article 13, which violates the rights of equality by using social media. So people who are using social media are normally convicted under this law. After the revoke of 370, there has been a huge ban on social media. And this article till now is in use. And once somebody has been warned, they have been asked to sign a bond to suppress, for their voices to be suppressed in Kashmir. And the last law, which I am going to be touch upon, which is the main law, which is the root cause of the atrocities being caused in Kashmir, is called AFSAPA 1990. It's called Armed Forces Jammu and Kashmir Special Powers Act in full. As we know that it is also been known as a law, rape law, weapon of war against the women, as we all understand and remember the Conan Poshpura incident in 1991. Now, under ASPA, Section 4B, destroying a property or burning property. So we see at the moment that the Indian Army are burning a lot of property, as we can see the recent news going on at the moment. So it's under Section 4B. And the reason is that they can do this on suspicion, and if they feel that terrorists are hiding in those properties. Section 4C, arrest on suspicion. So this law gives you power that even on suspicion, you can arrest, kill, rape, murder, and you can detain someone. Section 4D, enter and search. And Section 4E, stop and search. Section 5, break a lock and search. Section 6, person needs to be handed over to the police. But at the moment, due to these laws, police and the army are working together. Like under the DAA, normally the police takes over after 6 months. But at the moment, what we are seeing that they are even violating their own constitution because police and army are working together. Number seven is the impunity which is being given to the army, that they can get away with whatever they like. And this is the reason that many atrocities are actually happening at the moment. AFSAPA failed the international convention and treaties India has signed, especially violates human rights, as the definition under the act is so vague to be misused. I would follow it by the Justice Verma presented his report in 2013 after the Delhi rape case in 2012 and tried to protect women using the right to be safe under the law. But he suggested the AFTA law to have some amendments which were rejected by the armed forces till today, to continue to suppress the minorities by creating fear of rape. As being Asian, honor means more to us than our life. United Nations declared 5 elements of terrorism in 2006. First was audience, number 2, a plan of fear, number 3, involvement of harm, and number 4, innocent victims, number 5, political gains. Kashmiri don't satisfy any of them because being innocent, they have no reasons to be treated as a terrorist. I would like to also say that the day when India took over Kashmir, the assassination which was taking place on the 27th of October 1947, within 24 hours, you will be shocked to believe that the Indian army near Srinagar went to a village which is called Gogo. They swiped the whole village. And this is a proof that they always had immunity. They swiped the village just to teach a lesson to the Kashmiris that they wanted to be with Pakistan to create fear within the Kashmiri community at that time. And the article relating to this can be found online under First Blood. Before I go, I would like to actually um, touch upon this last law, which is in relation to the whole India. Even if India says that Kashmir is a part of it, it still cannot actually say that it has done anything for any community or for Kashmiris. They also have a law which is called the Scheduled Caste and Scheduled Tribe Prevention of um, Atrocities Act 1989 to protect minorities and lower caste, lower class, but not to be harmed by the upper class or by the other minorities. Public, but it has some principles as which seem like a joke that public, not behind doors or alone, can actually apply for this law. Like if something is happening to somebody behind the doors, or even if they're in public and there's nobody there. So the principle is that somebody has to be there in public to witness it. And this is one of the draconian law as well. Principle, unless there has to be somebody there, and there has to be a reason that that the minority or the tribe or the lower caste person has been humiliated. Now, this law seems a joke because if somebody can actually crack a joke in public and say that like it's a joke, but it's not really a joke, trying to actually scare them or trying to actually harass them, they can get away with it. So these are the type of laws that India is using at the moment, which can come under the category of a joke. Either there are laws which are like really like dangerous law, illegal laws, or either they are laws which are like a joke. So not to prevent. So this law is being told that it is to prevent hate and discrimination, but we don't see that it's going to be preventing anything when nobody, because none of the actions are normally happening in public. When these actions take place, they're always behind doors when there is nobody there. For example, as rape, for example, as murder. So I would like to actually say the last thing that under this law, no protection, protection was given to daily rights to 2002 or the farmers which are suffering since last year till today. Thank you for listening to me.
Unmute yourself. Vanessa, we can't hear you.
Thank you, Rihanna, for your deliberations. You touched on each and every law that Indian state has enacted in occupied Jammu and Kashmir, especially your reference to the Indian forces landing in occupied Kashmir on 27th of October 1947, and the pledge they took at the United Nations at that time that Indian army was there in Kashmir to protect the life, liberty, property, and dignity of the people of Kashmir. But we have seen for last 73 years how they have protected their life, their dignity, their property, and their liberty also and their life. And these all laws were incorporated to do away with all these things, with all these pledges which India has made at United Nations. Now I will come to another lady, Barrister Nida Salam. Nida, you have the floor.
I would like to say hello to all the panelists in this discussion. Also thank you to Vanessa for this invitation. It is my privilege to be here today. Indian government has enforced many brutal laws in Kashmir. These include Jammu and Kashmir Disturbed Area Act 1990, Terrorist and Disruptive Activities Act 1990, the Armed Forces Special Power Act 1990, Prevention of Terrorists Act 2002, Unlawful Activities Amended Ordinance Act 2004, the National Security Act, Official Secret Act, Jammu and Kashmir Public Act 1978 empowers the state and government to detain any person without a trial for 2 years under the pretext of maintenance of public order. Besides from that, the act fell short of the recognized norms of justice, such as equality before law, the right of the accused of appearance before a magistrate within 24 hours of arrest, fair trial in public, access to counsel, cross-examination of the witness, appeal against conviction, besides than that, protection from being tried under retrospective application of law, etc., etc. Even provision of the act through already unsatisfactory have been consistently violated. The detainees are not informed of the reasons of their arrest, and they are kept in custody for a much longer span of time than stipulated in the law actually. Besides than that, very importantly, I would like to refer, they are not even allowed to meet their relative and counsels, which is against human rights and international commitments and conventions, treaties, articles, protocols. These laws given the Indian forces extraordinary power to inflict with indemnity all kinds of abuses on Kashmiris in Indian held Kashmir, including detention, torture, use of force, shooting under the pretext of maintaining public order. International Human Rights Watch and United Nations Human Rights Committee has expressed severe reservation on these laws, describing them as license to kill and blatant contravention of all the covenants of basic human rights accepted worldwide. Stubborn and assertive child, India in the region constantly violated the United Nations resolution. It has further enforced numerous draconian laws in occupied Kashmir. Significantly, these repressive laws give protection to all kinds of illegal and abusive actions of occupying forces, as even no first investigation report can be registered without the approval of central government of India. No one can put a case for justice, and even a relative cannot meet with the prisoners. Unfortunately, with huge disappointment, I have to utterly condemn the promulgation of the new laws which attempt to alter the demographic and geographic status of Indian occupied Kashmir. I strongly call it violations of international law, commitments, and United Nations Security Council OIC resolution on the issue. International community should demand India on urgent basis to repeal these draconian laws and immediately stop its human rights abuses in the region. The Universal Declaration of Human Rights is an internationally accepted document, as states have adopted these provisions within their own constitutional acceptable frameworks to make its enforceable possible. 30 articles of declaration ensure alienable rights ranging from identity, liberty, security, and protection of laws. For more than 7 decades at the moment, the Indian armed forces are subject to constant violation of Universal Declaration of Human Rights. In 2018, United Nations revealed its report on Kashmir that impunity for human rights violations, lack of access to justice are key human rights challenges in the state of Jammu and Kashmir, and this is a very serious concern. Besides than that, in 2019, United Nations report stated a civilian killed by Indian security forces were around about 160 cases, destruction of civil property under cordon and search operation were almost 120 cases, Article 3, subarticle 1 of the 4th Geneva Convention 1949 prohibit cruel treatment, torture, humiliation, violence to life and in person. In 2010, WikiLeaks revealed that briefing to the United States diplomat in Delhi by the Red Cross related to incident of torture on detainees by Indian security forces and clear violations of the provision of Geneva Convention. Very, very importantly, in addition to that, India is now artificially changing the demographic profile of Kashmir by abolishing Article 370 of the Indian Constitution and giving right to Indian nationals to buy property in occupied Kashmir. It is common pattern in armed conflict and insurgencies that gaining local support changes that conflict dynamics, which in the case of Kashmir completely opposite. In this context, it is evident that India is violating the 4th Geneva Convention relative to the protection of civilian population of 1949. For instance, Section 3, Article 49 of the Convention states that occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Recently, on October 27, 2020, the Indian government passed 2 orders which amended 14 laws and repealed 12 clauses related to the status of buying property in illegal Indian occupation of Jammu and Kashmir. This notification will allow non-resident of India held Kashmir to buy immovable properties. Besides that, the phrase stated and used was being permanent resident of the state has been removed from the Jammu and Kashmir Development Act, permitting non-resident to own the property, and it's a violation of Article 72 of the 4th Geneva Convention 1949. And this is a very serious concern. Besides that, I would like to add, sadly, international organizations are merely just condemning Indian violations of all basic human rights of people in Indian held Kashmir. However, I believe that international allies, the international communities, the international institutions, somewhere, somehow, dramatically failed to take any relevant practical step. For instance, exerting pressure on India in shape of some sanctions to check these abuses, as well as laws granting the permission to carry out same. So India is in a breach of international laws, commitments, articles, protocols, treaties, and I strongly believe that India should be prosecuted for the violations of human rights in international court under criminal law as well. And international allies and the third world countries, the Asian world, need to take this matter very seriously. A lot of debates have been done, and as a young generation now, we believe that it's enough. And the next generation or the young generation in other part of Kashmir, which is held by India, like how they are feeling and they're looking forward at on international allies to come forward and bring these laws into practice rather than just to debate every single day. That's it. Thank you.
Thank you, Minister Nida, for your wonderful presentation. You also talked about the laws and the current laws and of the Geneva Convention, the relevance to the IIOJK and Geneva Conventions, how India has violated that, and your passionate appeal to the international community to come forward to the rescue of people of Indian occupied Jammu and Kashmir. Here I remember that when the India was the scrutiny in United Nations Human Rights Council and UPR in the 3rd cycle, there were some 169 recommendations handed over to the government of India to improve its human rights record, and 33 of them were pertaining to the repealing of Armed Forces Special Power Act and Public Safety Act. But unfortunately, what we have seen, neither government of India repealed these acts, nor they ratified the Convention on Torture, for which there were more recommendations on that from different states and other civil society actors. What India stated at that time when the UN Special Report on Extrajudicial Killings then Christoph Hans presented his report of the country visit to India, and he took a very heavy hand on India for overriding the basic rights of the people of Kashmir and Northeast by virtue of this Armed Forces Special Power Act. Then the Indian delegation at that time took floor and said, Mr. Reporter, you should behave like special reporter, not special prosecutor. So that is the Indian behavior. That is the Indian arrogance at the international level. What international human rights watchdogs, they write reports, they can write this, they can name and shame, but we know the international human rights mechanisms have very less teeth to catch India off it, but that is the responsibility of the states to come forward to rescue us, because all the decisions in the council or otherwise are taken by the states. So here I will write to request Advocate Parvez Shah Sahab, who is Secretary General of our party's Hurriyat Conference. Advocate Parvez Sahab, you have the floor. Your view from Indian occupied Kashmir, as we have listened to the laws like Armed Forces Special Power and others, you will deal on the laws which were enacted after the abrogation of Article 370 and 35A of the Indian occupied Kashmir. Mr. Shah, you have the floor.
Thank you, Wani Saab. First of all, I would like to thank Institute of Kashmir Relations, Kashmir Institute of International Relations, for raising the voice of the suffering people of Jammu and Kashmir. As all of the panelists are aware of.
If you can come close to the mic, because we are not listening to your voice.
Okay. After 5th of the August, people know that no voices are coming out from occupied Jammu and Kashmir. It is almost landlocked. And you know that all the newspapers in Jammu and Kashmir have been forced not to publish any news relating to the atrocities, or even a press release issued by the All Parties Hurriyat Conference or resistance camp is not being carried out by any of the newspapers. So All Parties Hurriyat Conference, which represents the aspirations of the people of Jammu and Kashmir, the only political...
Parvez Sahab, your tune is very low. We are very hard to hear it.
Okay, I will just... So what I want to say that All Parties Hurriyat Conference is highly thankful to those who are in the panel. Can you hear me, sir? Hello? Hello?
No, we, Parvez, Advocate Parvez Ahmed.
Can you hear me?
If you come close to the mic, maybe there is some obstruction to mic from your side.
Okay, sir. Can you hear me now? Is it okay?
There is still some problem, and you are gone. Your camera is not there. Yes, you come close to the mic.
Yes, please. Can you hear me now, sir?
Yeah.
It is okay. Thank you very much, sir. What I mean to say that the voices of the people of Jammu and Kashmir are not coming out. And as you know, in different conflict zones, international NGOs are allowed to monitor the situation. But Kashmir is the only territory, only conflict zone where the non-governmental organizations or NGOs are not allowed to visit or report about the situation of the Jammu and Kashmir. But anyway, we are thankful to KI institutions like KIR and those friends who are sitting in this panel and who are talking about the Kashmir. All of my colleagues have in depth, in detail, discussed the laws which are applicable in Indian occupied Jammu and Kashmir. As you just put a bar to me that I have to only discuss the post 5th August situation. If we go through this, the law which was passed on 5th of August by the Indian Parliament, that is Jammu Kashmir Reorganization Act. This law changed the course of the history. This changed the Jammu Kashmir, all laws which were not applicable to Indian occupied Jammu and Kashmir. those laws were made applicable. I will just say that since 5th of the August, the state of Jammu and Kashmir, as I'm talking of Indian occupied Kashmir, it is being run on ordinances and notifications. No law is being discussed in the parliament. And unfortunately, I will talk just one or two laws which are which have been made applicable. You just made the mention of. I will just talk of one law, that is the banking law. How it affects the Kashmiris, as you are aware of the fact that before 5th of the August, one law was passed by the Indian Parliament, that is that was known as surface law. That was under this law, the government of India asked the people who have pledged their properties with the banks and who were not in a position to repay the loans to if they do not pay the loans, their properties who are pledged with the banks, they will be forfeited and the loans will be redeemed. But at that time, the High Court of Jammu and Kashmir, which was existing with its special jurisdiction, it nullified it and asked the government of India that this law is not applicable to state of Jammu and Kashmir because it has a special status, and the land laws are protected under Article 35A. But once India abolished this law, the bar was removed, and now the those who have pledged their properties with the banks, and the condition at that time, the court has put only one condition: if the banks have to redeem their loans, the condition will be the buyer will be only the Kashmiri, a state subject, because non-Kashmiris were not allowed. So they put that law in abeyance, and that law did not come into operation. But after that 5th of the August, when this bar was removed and a new banking ordinance was passed, as per this law now, the Kashmiris are being forced to repay their loans, and we are knowing their economic conditions, that that they're not in a position to pay the loans, and hence the banks are being forced to redeem the property, and the buyer, ultimately the buyer is the Indian. This is the way how Indians are behaving. 2 days back, there was another notification by the government of India in Jammu and Kashmir, and people were, the schools, especially the schools, were asked to paint their buildings in a particular color, which will give the look, which will give the impression that the whole Kashmir has been Indianized, and they have been asked to hoist the flags of the India, which is again, which people do not agree, and which is against the aspirations of the people, because people of Jammu and Kashmir have never recognized the Indian flag. And the force is in such a way they want to implement this notification, that the teachers and the in charge of these schools have been forced that they have to implement this they have to implement this government notification. If they do not agree, or if they do not implement, then this notification, a strict action will be taken against them. We will just talk of, there was another notification about the mines, and which we have, because it is a rich country, in a rich state which has its natural resources, and we have just seen that one more note, as per the notification, the non-state subjects were asked to file their tenders for the contractors for extraction of the mines, and even the sand from the rivers of Jammu and Kashmir. And the Kashmiris, when we know that there was no online service, people were not in a position to find the online tenders, and they couldn't participate of the whole, the mines, as well as the sand and other resources, these resources we have in Jammu and Kashmir. Now the full control has been taken by the government of India. So there are number of laws, and I will mention one more notification, one more law, that is when the Domicile Act, we had our own Domicile Act, because in 1947, when Maharaja Hari Singh acceded, rather, as per Indian version, they have signed in a so-called instrument of accession. We had given, the Maharaja has surrendered 3 subjects with the government of India. That was defense, foreign affairs, and communication. He has retained its sovereignty, And so the government of India could not make any legislation beyond this, but unfortunately, the main law which has changed almost the total situation in Jammu and Kashmir, that is the Reorganization Act. And this law, under this law, every new notification and new laws are being passed. I was just talking as one of our panelists just talked about the this Public Safety Act. This is a state law. This law was passed by the state government in 1987 to deal the timber smugglers. And at that time, what was mentioned in that, it was a person acting in any manner prejudicial to the security of the state. Under this, the timber smugglers were being held and put behind the bars. But unfortunately, in 2020, one more amendment was made to law by design to deal the Kashmiri political leaders, those who are resisting against the Indian occupation. The another amendment was that any person acting in any manner prejudicial to the maintenance of public law and order. It widened the scope of this Public Safety Act. And after this, we have come to know that this law was declared lawless law by the Amnesty International. And when we were in Geneva, I was with you in 2018, and at that time, Human Rights High Commissioner has raised number of questions about this law. But unfortunately, instead of accepting the observations of the High Commissioner, India maligned the High Commissioner. Even we were there, and you are aware of this fact, that even our team was even maligned, that this the High Commissioner's report was just on behalf of the delegation which was sitting in which was at that time in Geneva, although the report was published, submitted by the High Commissioner on the remote monitoring. Had there been no remote monitoring, but the access is given to High Commissioner or international NGOs, what would have been the situation? India would have been completely exposed. But India is in a habit of criticizing those NGOs or those international organizations who raise fingers or who talk about the systematic human rights violation. One more thing I would like to put on record for the panelists is the Kashmiris are resisting. They are not fighting. If we go through the the statements of the Indian police chiefs or army chiefs, what they have said, that there is the presence of less than 200 freedom fighters in occupied Jammu and Kashmir. But when we see that there are more than 900,000 troops who are dealing with these 200 freedom fighters, you see there is no parity. And unfortunately, since this statement was issued by Government of India, more than 500, 600 people have been killed in Indian occupied Jammu and Kashmir. And these laws are not being abolished. You see, if we talk of Armed Forces Special Powers Act, this law was applicable in Mizoram and other states. But after the Supreme Court of India, there was a direction from the Supreme Court of India that there should be investigation in the cases of missing persons who were taken by the these security forces and who are not known, whose whereabouts are not known. But that same is the case in Kashmir. But what is the difference of how the Indian courts are behaving with the state of Jammu and Kashmir? We have seen in 2016, 2018, we had the thousands of pallet victims in Indian occupied Jammu and Kashmir. Even we All Parties Hurriyat Conference, through its legal team, applied to the Supreme Court of India about this petition is pending for the last 3 years and no decision has been made so far. We challenged this Jammu Kashmir Reorganization Act in the Supreme Court of India. 2 years have passed, nothing has come out of it. So when the people are being arrested in Indian occupied Jammu and Kashmir, whether they may be under Armed Forces Special Powers Act, they may be under Public Safety Act and or Unlawful Activities Act, courts are not taking the cognizance. They are using the delaying tactics, which is a major concern for us. for us. Because if we see this Unlawful Activities Act, this is just a presumption. If a security person just presumes that a particular person is involved in, he may commit a crime or he may disrupt the law and order, he will be taken into custody, and for the 6 months he is not eligible for the bail, because generally the law is that bail, you can claim bail as a matter of right. And here the situation is different, because the person who is detained under Unlawful Activities Act, he is presumed to be guilty. This is you see how these laws are made, and what is the intention behind these laws. You are just talking about the statements which have been issued by United Nations, and how India negated, and how India tried to malign and gave a shut up call to these international organizations, or those people who have been raising the voices for the people of Jammu and Kashmir. You see how India is behaving, and how India is taking the international community about the Kashmir. But now the question arises that if India is the member of the Human Rights Council, an important member, and it has even taken the seat of this council for a couple of times, but when this council comes to India, when it talks about the human rights violations of the Kashmiri, you see how India is behaving, and what kind of arrogance they are showing. So in this situation, it is very important for Human Rights Council to take the cognizance of the Indian attitude. Until and unless the Human Rights Council, to which India is a party, takes a strong position about the human rights violations, till then there is no possibility that there will be any kind of a relief. As you just mentioned, that India is not signing convention against the torture for the last couple of years, and the countries have raised serious questions, but unfortunately India is evading what the issues have been, and how it has been taken by India. So, but I'm to some extent I am to this satisfied that voices are being raised by international players. Now we have to wait, because the room was not built in a day, but the situation after the 5th of August has changed. Friends like you, friends like sitting in this panel, they are discussing the Kashmir, they are raising the voices, and we hope that your voices and your concerns will be taken seriously by the international community, and one day the goodwill will prevail upon India, and they will just go for the resolution, because there is no other option for the India, because people of Jammu and Kashmir have not given up their resistance. They are resisting by every means, by every day. Yeah, 2 days back we have seen that more than a dozen of houses were destroyed by Indian occupation forces, but people have come on the streets, they have resisted. So we are to this extent we are satisfied that people are resisting for a genuine cause, which is a legitimate cause, which has been recognized by the United Nations, always by the Human Rights Council. So, Mr. Wani, I'm highly thankful. I don't want to take more time, because I know I want to listen those panelists who are very valuable panelists for me, and whatever it carries weight. So thank you very much for giving me the time and listen to those well-known and very honorable panelists. Thank you very much.
Thank you, Mr. Parvez Shah. This was Parvez Shah giving us the opinion of the people of Kashmir and that of the All-Party Juliet Conference, and overall view of these abusive laws. Just one thing, that it is not from last couple of years, but it is from 1994, when the Convention of Torture came into force. India did sign it, but thereafter they did not ratify it on one or the other pretext, and the same is case with the Convention of Enforced Disappearances. Now, Ambassador, we have listened to all panelists about the situation in Kashmir, about Punjab, about the Sikhs, how the India is using the abusive language to name those people who are struggling for their just rights as terrorists, and using abusive legislations against them to curtail their freedom and to curtail their right to express themselves, and thereby creating a false narrative around the globe around them. So now floor is yours. We would like to hear from you. Dr. Hasham Boyasad.
Yes, thank you very much for the invitation. After listening to all the panelists and the accurate legislative law, my paper is going to be a bit on the historic issue, and I'm going to conclude with the 4 points of what we see as International Human Rights Council and International Human Rights Commission, that we are working at the UN level with all these aspects and all these points that are really, I can say, critical. But in the meantime, we have to stand still in the middle of the issues, looking to the rights, and try to bring points together in order to solve this critical issue that has been since 1947, even a year before the Palestinian-Israeli crisis. For so, I'm going to start by saying that the Kashmir dispute is considered a territorial dispute mainly between the state of India and Pakistan, which began immediately after the partition of India in 1947. As for China and Russia, it played a secondary role at times. India and Pakistan disputes Kashmir 3 times, which includes the Indo-Pakistani wars in 1947, 1965, and the Kargil War as well in 1999. I'm not going to go into the details of that because I believe you all know that. But since the British Parliament passed the Indian Independence Act on July 17, 1947, that ended British rule, and then a month later, the decision to divide the Indian subcontinent, the Kashmir issue has emerged as a knot between the newly formed states of India and Pakistan. The partition decision included that the Muslim majority states join Pakistan and that the Hindu majority state join India, provided that the states joining is in accordance with the will of the population, taking into account the geographical divisions in each emirate. The reason why I'm pointing out this historical is to reach out to my 4 points that I mentioned at the beginning of my speech. The partition decision passed without any difficulties in all states except for only 3 states, namely Hyderabad, Junagadh, and Kashmir. In the Emirate of Junagadh, its Muslim ruler decided to join Pakistan despite the presence of a Hindu majority in the Emirate. But in front of the opposition of the majority, the Indian forces entered and held a referendum that ended with the Emirates' accession to India. As for Kashmir, its status was different from the previous 2 emirates. Its Hindu ruler, Hari Singh, decided to join India, ignoring the desire of the Muslim majority to join Pakistan and ignoring the previous British rules of division. But his fear of the reaction of the Muslim street prompted him to present a treaty that he offered to the 2 countries to keep the situation as it is. So Pakistan accepted the treaty while India rejected it. Events developed rapidly after that, and the first armed fighting broke out between Kashmiris and Indian forces in 1947, which resulted in India's occupation of 2/3 of the state. Then the United Nations intervened in the conflict, and the Security Council issued a resolution on August 18, 1948, stipulating a ceasefire and holding a referendum to determine the fate of the region. Now, the United Nations suggested that the Muslim majority parts join and share borders with Pakistan for Pakistani sovereignty, and that the other Hindu majority parts that have common borders with India should join Indian sovereignty, but this decision remained a dead letter and did not find its way to implement it. Under Shimla Treaty Agreement, India kept some of the Pakistani territories that is controlled after the 1974 war, and Pakistan also kept the lands that it controlled. This remained ranging from escalation and tension to calm until April 1987, when an armed uprising erupted in Kashmir after India falsified their elections, and this uprising soon turned to armed. I'm gonna brief my paper just to end, to say that to this day, it does not seem that there is a ready or possible solution given the current international situation and the new balances in it. But it is possible to imagine multiple possibilities that may lead to a solution that we adopt as International Human Rights Council and International Human Rights Commission, including the 4 points I'm going to mention herein. Number one, maintaining the situation as it is and considering the ceasefire line as an international border with the agreement of the two parties. Two, the annexation of the Muslim part of the region to Pakistan and the Hindu part to India, and this requires the consent of both parties as well. Three, the region granted in its independence to become an independent state, and its fate is to be chosen through a popular referendum. Number four, the establishment of two independent states in the region. This could be one of the main points that could be also discussed. The desire of the people of the region is for the independence of the region, but the game of the international interest prevent the establishment of this country to this day, because India and Pakistan feel that this country will turn to the other side, which affect the strategic balance of power at the doorstep of Southern China and Russia. And I thank you.
Thank you, Dr. Sanbosat, for your contribution. You dealt with the historical perspective of the dispute. You discussed about the Junagadh, Hyderabad, and Kashmir situation. Unfortunately, when we discuss the Junagadh situation or Hyderabad situation, what India accepted in Junagadh, they did not accept in Kashmir. They accepted, they annexed Junagadh, then held a referendum there, and then called it that it was people's decision. But the same was not acceptable to Indians for Kashmir, because they knew the Kashmiris will not accede to India. As far as the Maharaja's accession to India is concerned, that accession was surrendered by India. According to the UN systems, that was surrendered by India in the United Nations by taking their complaint over there and by agreeing to the United Nations resolutions for a fair and impartial plebiscite in the territory. So that Indian claim that the Maharaja of Kashmir has acceded to India, that claim thereby, when they took the case to the United Nations, they surrendered that paper of accession to the United Nations. So now, after 5th of August, what India has done, even that claim, which India has, that has done away with that claim, then now they have fully annexed the Kashmir. Now it is an occupation. Otherwise, they were in Kashmir. It was by virtue of those UN resolutions, but they are not abiding by the resolution. As per as your statement that there are 4 solutions you gave to the Kashmir that the both parties should agree upon, is that the Muslim part should be to the Pakistan, and that non-Muslim part with the India, with the formation, with the consent of the people of Jammu and Kashmir, and with the consent of both the parties, and also that the other way is that the permanent, and that LOC may be made a permanent border, and a solution lies in there, and all that. But unfortunately, what we have seen that as Pervez, Advocate Pervez, who is Secretary General of the All-Party Hurriyat Conference, the main group was contesting in Kashmir for this right to self-determination. Their manifesto also says that the Kashmir should be resolved under the United Nations Security Council resolutions, and also by, if not possible, but then by tripartite talks between India, Pakistan, and the people of Kashmir. But we have seen over the years now that Indians, whenever they come under international pressure, whenever they have any international pressure, they come to talk to Pakistan or they pretend to talk to the people of Kashmir. When at international level they are asked to talk with the Pakistan, they say Pakistan is a facilitator of terrorism. Pakistan has no local stand-eye in Kashmir. We are talking to the people of Kashmir. When it comes to the people of Kashmir, they say these people of they are the stooges of Pakistan, or they are terrorists, or we are not going to talk to them.
You meant there is a double standard? There is a double standard?
Yeah, after 5th of August, now what they did, all those people who had been doing the pro-Indian politics in Kashmir, they were also branded as terrorists, as Pakistanis, and their politics was also, they were put behind the bars. So what we are discussing is that India is colonizing now the Kashmir. Like it is a now colonizer. It's not only an occupier, it has now colonized the Kashmir. It is implementing, it is greater Hindutva agenda, as Mr. Jaisingh is also telling us about, that they don't accept Sikhs as a separate religion. What they say that India is for now only for Hindus, and if you have to be India, you have to be a Hindu. Like that, the recent laws which India passed, like CCA and NA and all these all point finger to that, what India is going to do. So this is the Indian standard, and whom we will talk, because India is not ready to talk anybody. India is not ready to accept the advice of anybody. As in my intro, I said that recently, it was only yesterday, what Indian Foreign Minister said to the criticism made by the Swedish Institute when they said that India is no more a democracy, it is an electoral autocracy. And to this, the Indian Foreign Minister said that we don't need any external advices or certificates from these so-called custodians of human rights. So this is the attitude of India, and we need to condemn this Indian attitude, this Indian arrogance in black and white. And we should not mince words in that what is current regime of India doing and what their agenda is. So with this, I open the floor for if anybody has to.
Mr. Altaf, Mr. Altaf,
Yeah.
may I make my point, and I hope you understand my position.
Yeah.
At the UN, we go by the UDH, the Universal Declaration for Human Rights, the UTHR.
Yeah.
And the belief of the religious sect, it's one of the main points that is mentioned at the UDHR. So I believe all the political talks that we've been listening and we've been hearing here and that and there, I believe it is only to emphasize the demands from each side. Therefore, when it comes to the serious talk, we believe that everybody will go under the international law and under the Universal Declaration for Human Rights that was adopted by 193 states. And I believe India and Pakistan also, they are committed to that. For so, we should always take the positive part, not the negative part. Now, according to some of the terminologies used at this session, I personally, and from my position, we cannot adopt any, neither from the Pakistani nor from the Indian, because this is a political speech. For us, we work in diplomacy, and diplomacy do not accept or do not adopt any, if you want, severe description of the issues. I understand the right, I understand the fear, I understand the way they approach the issues. But for us, we are in the middle. We look to the rights. We look by the conventions and bylaws.
Thank you. Jaisingh, if you have anything more, sir.
Yes. Sorry, I just wanted to add to Dr. Hasim Boi's statement, just that when India did become independent and when Pakistan did become independent, there were other states that were adversely affected. One of them was also Punjab. Majority of the deaths that are recorded during partition happened in Punjab itself. I would just hope that there would be an expansion of the recognition that during independence, there are other regions of South Asia that are contested. Furthermore, India's compliance with its international obligations should be seen for what they are, irrespective of the diplomatic language that governs relationships. Now, the UN has stated nations that fail to conform to UN standards or their international obligations are not afforded the rights or protections such as territorial integrity or are immune from criticism. At this stage in time, India is fast approaching almost a totalitarian state in the sense that there is a one religious ideology. It is forced upon the peoples, and those, institutions, corporations, and governments, they work in a unison, in a cooperative manner to promote this ideology. Conflict is on the horizon. India is aware of this. The UN has an obligation to avoid conflict. And I hope that diplomatic language is not given more weight, and the primary obligation of the UN to avoid conflict is not sacrificed solely for this idea of appropriate language and flowers and happiness. These are my concerns, and I respect your position as an ambassador, and I understand your position. But India is fast approaching a critical point, and the people of India, especially with the farmer protests that are happening right now, are fast approaching a critical point in its history. Thank you.
Yeah, let me just rectify to your good knowledge that during all the sessions at the UNHRC, we are cutting off any inappropriate language towards countries, especially from the intergovernmental, the ITOs and the NGOs, civil societies. And this is something that's not being said today. It's being implemented at the council, and we are restricted to that. So I hope that, because if we are seeking results, approaching the issues with an appropriate language maybe gives more results than an inappropriate language that gives states the alibi to jump over the issues and take the inappropriate language as an alibi to avoid implementing certain rights. So this is why we emphasize on that, and we look forward to see this implemented in all the webinar sessions. Thank you.
Thank you, Ambassador. You rightly point out that we should take care of this language. That's why I earlier said that when we take the sessions in UN, or we take care of this language, we do submit written statements, and also during the oral statements, we do take care of that. But I just mentioned about the response from the Indian diplomat to the UN Special Rapporteur. When the Special Rapporteur said that India has overridden the basic rights of the people of Kashmir and that of Northeast and Punjab through the Armed Forces Special Power Act, the reply from the Indians was that, Mr. Special Rapporteur, you should behave like a special rapporteur, not a special prosecutor. So when a state uses such a language, when state says that a person, or he brands a person, that by started this discussion by abusive language, by criminalizing the language, that is what the Indian state has done. But the current Indian state is doing more. They incite the hate speech in India by them, and the farmers' protest was also branded as a terrorist protest and all that. That's why then the activists have their own way of expressing themselves. When they don't get redressal from anywhere, then they have their own way of expressing them. But we do recognize that there should be a way of expressing the things. That's very good. Parvez Shah Sahab has hands up. You want to say something?
Thank you very much.
But before, I'm not cutting you, but let me just quote on what it was just mentioned. I am a former ambassador, state ambassador, and I understand the language of the states in any council, in any sessions. And but we are trying to do our best at these sessions, and we are trying to avoid conflict between states and global NGOs. And this is why, as a former also ambassador, state ambassador, the language should be also restricted to appropriate approach, because it also reflect bad image on the country. For instance, I'm not going to go into details on what states are doing this at the council, because some of it is a private talk, but some of the states are trying to neglect global NGOs, and they are trying to pull them out from the council. Now, what we discussed with our president, the Ambassador Nazhat Shamim Khan, recently to try to find ways to stop states from harassing NGOs, okay, and threatening them of pulling them out of the council. And I believe that this is not going to happen, because former HRC President Ambassador Elizabeth Fisselberger and the newly appointed HRC President is well aware of the whole image, and they are backing a lot the NGOs. And this is why I am saying this today at this panel, that any inappropriate words could give a bad image to the subject we are dealing with. Thank you.
Yeah, thank you, Ambassador. Very wonderful explanation of things. Yeah, Mr. Pervez.
Mr. Wani, thank you very much. I don't know whether I was the right person for this webinar, because what has been said that these all speeches were political. Although I represent the political organization which is fighting against the Indian occupation, or the resisting Indian occupation. First of all, when we are talking about the human rights, you cannot ignore the political issue, the political aspect of the Kashmir issue. We see that until and unless I say India is occupied, it is useless for me to sit in this kind of seminar, because it's an occupier. There is no dispute at all. It is a United Nations recognized dispute. There is no dispute at all. First of all, we have to, as our well-learned ambassador has said that about the regions, the first of all, we have to see how we will ascertain the will of the people. It is very important. Before we are sitting on the table about negotiations, this part should be given to this part should be given to this. Who will ascertain it? It is although the United Nations resolutions is the only procedure available with us. According to that procedure, the will of the people can be ascertained. Secondly, when we're talking about the language, we have been monitoring Indian media and Indian leadership since 5th of August, how they are behaving, and our political leaders who do not have any role in militancy, or rather they have been peacefully struggling. I have the case of Naeem Ahmad Khan, I have the case of Sayyid Ali Shah Gilani, I have the case of Mirwais Umar Farooq, a number of who are behind the bars on the charges of sedition. And the sedition is the law which was applicable to India before the partition. Even you see that Mahatma Gandhi, he said this is the premise of all laws in Indian Penal Code, and in Jawaharlal Nehru said that this law should be abolished, but it is still applicable in Indian occupied Jammu and Kashmir. If I will not talk about that, how my people are suffering, how they are being put behind the bars under these laws, this is the only language. What language I should use? If somebody considers and
okay.
Good.
Okay, thank you, Pervez Saab.
Thank you very much.
Thank you, Pervez Saab, for your clarification of your thoughts. Actually, what we are discussing, you expressed yourself very well. But the ambassador's approach was that when we are talking on a panel or in a webinar or associated with United Nations, we should abide by the rules and regulations of the United Nations and use the specific language which they have, and to make our point known that there is no, that's in United Nations, Kashmir is a disputed territory, so we can use this and all that, what we say. But what Ambassador point was making, Ambassador, that was that over the years, and what we have seen ourselves, that the spaces for civil society in the Human Rights Council are shrinking. And the more the countries are trying to shrink them more and more and give no space to the civil society. And for that purpose, what Ambassador said, they have discussed with the current President of the Human Rights Council, which had only on 14th are discussions with the NGO representatives only, and also before that, so how to counter this. And she's a very strong advocate of the civil society, and we should encourage her. We should give her more strength so that she can do with. She was the one, I must appreciate her, even on this online panel. It was not possible to make the video statements online through as a general debate. And she made it possible. Countries were not willing to give a general debate to all the civil society actors, but she and her bureau, they contested the council, and they said, no, civil society should be given the space to of their own, and that's why we are making online statements on different agenda items in the council. So we should appreciate the president's role and also our bureau's role, what they are doing for the inclusion of civil society in different debates. I think Rihanna wants to add something.
Thank you. Yes, I was actually going to ask that if I can get an opportunity to add, and it's quite like surprising that you did actually give me the opportunity before I asked. I would just like to add that like all the laws I've been talking about, like I would say that like we should highlight them, and if we like, we can use them against India, like especially the AFTA, like that's the evidence in itself. That India is committing war crimes and they are inhuman laws. But at the same time, even the people who are living in India, they can actually use Article 13 of the UAPA 2002, and they can actually go to court as well and say that like they are not getting equality, like they can't use media within India. And even if India is saying that Kashmir is a part of India, it's still violating it. So India is in every single way violating the laws, being a disputed area or even being a part of India. So I would just say that all of us should actually get together and we should actually make sure that the United Nations actually realizes that what is going on. And it's very, before I go, I would like to add on, it's been 31 years since AFTA 1990 has been going on, like has been enforced. And I'm very surprised the United Nations hasn't taken any action. And I don't see many people talking about it. People talk about the atrocities, but they don't talk about the law. Till we don't talk about the law, we can't actually take India to court. So it's very important that we understand the laws and we talk about more about the laws and we highlight all the atrocities taking place. Like, for example, at the moment, India is burning houses and is burning property. So that comes under after 1990 section 3. So we should be talking about these sections so people understand and we can take it forward. And with this, I would like to thank like each and every person in this panel for coming today and listening to me and giving me the opportunity. Thank you.
Thank you for your contribution. And yes, you are right. We are talking about these. That's why I recall it that one of our friends from Northeast, when he met me in the United Nations Human Rights Council, he said that it was blessing in disguise that this Armed Forces Special Power Act was enacted in Indian occupied Jammu and Kashmir. That is why it became very much, the people around the globe became very much aware of it. And you people brought it to the council, you people brought it to the notes of, but we people in Northeast have been facing this law since 1958. So this law was enacted in Northeast 1958, and then in Punjab in 80s it was enacted in Punjab. At this time, when we are talking in India, like the ambassador was telling us that civil society spaces are being strengthened in the UNHRC. Like that in India, after the Modi regime took in, we have seen lots of those people who were championing the civil rights in India, civil liberties in India, from northeast to the south to the next slide belt and others. They are in jails. They are, because the sedition charges against them, they are treated as terrorists by the Indian government. Indian government doesn't want to listen at this time anything. They won't listen only that what comes from the Modi regime, not from what is written in the book of law, what is written in the Constitution of India. They don't want to listen that. They want to listen only how the BJP is explaining the law. And you said about in your deliberations earlier, you referred about the Verma Commission, which was after Delhi rape case. I recall it when Delhi rape case has, and that MBBS doctor was raped in a bus by a driver, and then the Verma Commission was established. They also said that repealing of the Armed Forces Special Power Act, and but what the government of India, what the Armed Forces Special Power of India, they said that the Armed Forces Special Power Act is like a Bible for the Armed Forces of India. If this is repealed, then the morals of the armed forces will go down. But the repercussions of that we have seen in Delhi. Delhi has become a rape capital. Now, after every 5 hours, there is a rape in Delhi, and Delhi has become a rape capital, and everywhere there is rape in Delhi. And so Indian society is reaping the fruits what they have sown in the rest of the country by enforcing these laws and by providing impunity to their armed forces. So, Nida, you have anything to add?
Yes, I would like to add in reference to the ambassador, Dr. Hassam, whatever he said in relation to the language. I would like to refer to the language of Sushmita Swaraj in United Nations General Assembly that's used under the umbrella of current government for Pakistan. That sort of language should be entirely condemned from our perspectives. Secondly, I strongly understand the position of the ambassador, Dr. Hassam, at the moment, the way he referred in terms of being neutral, but he gave the reference of United Nations Universal Declaration of Human Rights. In reality, India is in a breach of every single human right. India is in a breach of all the commitments. India is in a breach of international protocols, treaties, articles, convention. As I'm from Pakistani part of Kashmir, and I have exercised all my basic fundamental human rights, which Pakistan is committed. And when I see and experience and witness my other family members in occupied Kashmir, that is a real violation. And people sitting in this part, in different parts of the world, are concerned. And yeah, so that's the thing. But we strongly understand the position of the ambassador, Dr. Hassam, from all perspectives. So that's it so far.
Dr. Vikas Ali Kausar.
Yes, thank you. Thank you.
Dr. Vikas?
Sorry.
Dr. Vikas Ali?
Yeah, thank you very much. Just on the language, of course, this is one of the very important part for all of us in many ways. But sadly, as we were discussing this language of resistance that we have actually here, this is the product of certain instances and realities. Actually, the problem with the language, of course, it's a very tricky thing in many ways, but just want to say, of course, I mean, do we have any agreed language of people who are oppressed or victims? I mean, sometimes it's very difficult to sort of put things like this. But of course, just just one thing on language. There is a larger question on the international systems and their efficiency on addressing the people who are victims or might got affected from the conflicts. Maybe it's part of on their side, as well as if there would be no redressal or the solution of the larger disputes, the sort of language and expression, and people get more frustrated over the period of the time. So I guess these all things are interconnected, and I hope so we in over a period of time find better language and ideas to express the narrative of people, those who are suffering and suffered. Thank you.
Thank you. I understand the grief of people that you mentioned, and one of the colleagues, also panelists, also mentioned. But those who are violating laws, even by languages, they will be, I mean, paying for that, because using also inappropriate language will put them under a lot of pressure. And let's say that we are looking always towards diplomacy language, and we think that this is the best solution to approach issues. And if you can excuse me now, because I have to run, I have a CSW 65 at the UN New York, and it's going to start in few minutes. If I can dismiss myself, and if it is acceptable from your side, I will be very
yeah, we are also closing, Ambassador. Thank you
Okay.
very much for your insightful deliberations, and thank you all panelists for coming to
Thank
this
you all.
webinar, for sparing your time, putting out your wonderful thoughts forward for the public opinion and for our knowledge also. I'm thankful to my coordinator, Shubh Taishar, who coordinated with all of you for all this, this webinar. Thoroughly, I will say that what Ambassador said, I echo with him that we should we should use the right language as being propagated by the UN, and also we should be engaging with the people rather than disengaging. We should try to engage with the people more and more so that we can find some common spaces for a peaceful resolution of not only of Kashmir, but of other issues also, like that of that Sikh issue, Punjab's issue, and other certain issues around the globe. That the only thing is that when we engage with each other and accept each other's point of view, and then look forward for the solutions. With this, I thank you all and beg leave from you. Thank you all.
Thank you, Manisab. It was always great and pleasure to be in this webinar with you and the rest of the panelists. Thank you. Have a great evening, everyone.
Thank you. Thank you. Great evening.